Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you from our fantastic Central Washington location. Freezing my shtukas off out here right now, trying to record this video early in the morning before I get on the road. But listen, there's some really important updates I want to get you up to speed on real quick as it relates to force reset triggers, wide open triggers, Operation Reticent Recall, ATF's efforts to reclassify a trigger standing alone as a machine gun. Now, we know there was an injunction by a court in Texas already issued on that rule. Well, the United States government has asked for that injunction to be stayed pending the rest of the appeal, and the court has a pretty strongly worded answer. So today, let's spend a few minutes and let's talk about the court that refuses to revive ATF's trigger rule. Okay, so the case we're talking about today is National Association for Gun Rights v. Garland. It is a case that's filed in the United States District Court, Northern District of Texas. It is a challenge to Operation Reticent Recall, ATF's new and improved investigation about forced reset triggers. The court granted an injunction. The United States government has filed a motion for a stay pending the rest of the appeal. The court has ruled as follows. Before the court are defendant's motion to stay preliminary injunction pending appeal filed November 6, 2023. Having considered the briefing and applicable law, the court denies defendant's background for a stay pending appeal. Now, anytime we are asking a court to step in and stop an action which is already underway, remember, we have to show that, one, we're going to suffer irreparable harm, and number two, we are likely to prevail on the merits. Now, in some courts, there's additional balancing factors that also go into effect as far as the effects on public policy. The court, in determining whether or not the United States government is likely to prevail on this argument, ruled, to begin, the court considers whether defendants have made a strong showing that they are likely to succeed on the merits. Having reviewed defendants' arguments as to this factor, the court concludes that they have not made a strong showing of a likely success on the merits. And of course, that gets us all back to how the federal law defines machine gun versus how the actual force reset triggers and wide open triggers actually function, and they clearly don't fall under the purview of that definition. Now, of course, the United States government would have also had to show irreparable harm. The court ruled, turning to the second stay factor, the court concludes the defendants have not shown that they will suffer irreparable harm absent a stay pending appeal. Although defendants focus considerable attention on this factor in their briefing, none of their arguments are availing. And obviously the United States government argued, all of the carnage and everything that's going to happen if this rule is not enjoined. Now, there is some interest balancing that the court has to engage in as well, public policy and things such as that. And the court ruled as it related to those factors. The court also finds that the remaining two factors, comparative balance of the equities and the public interest, likewise do not justify a stay pending appeal. The court previously balanced these competing interests and reaffirms that conclusion absent convincing otherwise. Because defendants once again failed to shift the equities in their favor, the court addresses the public interest factor. And again, the United States government kept saying, but these turn these guns into machine guns, and therefore we have to stop it because the carnage is going to be so great. The court responded as follows. Furthermore, defendants also repeatedly highlight that the FRT's rate of fire is similar to how quickly a machine gun fires. But this fact is irrelevant to any consideration of the potential harm posed. That is because the statutory definition of machine gun, as emphasized by Cargill, does not define a machine gun based on this attribute. In contrast, plaintiffs would be substantially injured by a stay. The court has already found twice, in slightly different contexts, that plaintiffs face a substantial risk of irreparable harm if defendants are not enjoined from engaging in enforcement activities. And ultimately, in shooting down the Department of Justice's request, the court stated, at bottom, the preliminary injunction may frustrate defendants' enforcement and retrieval interests. But for the reasons discussed, any injury to defendants continues to be outweighed by the plaintiff's strong likelihood of success on the merits. Defendants have not only failed to make a strong showing of success on the merits, but have also not identified how their asserted harms will still exist if they do not prevail on the merits, and these two factors are most critical. Therefore, the court concludes that defendants have not met their burden of showing that the circumstances justify an exercise of the court's discretion to grant a stay pending appeal. Accordingly, the court denies defendant's motion. Now, that order was signed November 16th. It's going to take me a day or two to get this video edited and out to you, but listen, as we speak of right now, the ATF rule on force reset triggers, wide open triggers, Operation Reticent Recall, and all of that is officially dead at this point. Now, I understand that some people are still getting calls and letters from the ATF, and you need to consult with local counsel immediately if ATF is still attempting enforcement efforts against you about these. Now, I know I gave a lot of videos and advice earlier, but that was when the legal framework was far different than what it is today. We have an injunction in place, and you need to consult with local counsel if ATF contacts you about anything related to any of these items. The case, once again, is National Association for Gun Rights v. Garland. We'll link it up down below. It's brought to you, of course, by our good friends for the National Association for Gun Rights. Dudley Brown and everyone over there, kudos to you. You guys did some fantastic work, continue to do fantastic work. If you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information, it's down there in the description box. Now, in the meantime, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.